Okay, good morning. Let's get going. Thank you all very much indeed for joining us this Brick Court Chamber seminar about the recent test case brought by the FCA to test whether various business interruption policy wordings responded to business interruption losses caused by COVID-19. This seminar is, my name's Simon Salzedo, by the way, and this seminar is going to be in 4 parts. So it's like the Asterix version of Roman Gaul. I'm going to start with my colleague Michael Bolding, who is going to tell you about the Supreme Court's decision in relation to the construction and interpretation of the insurance provisions that were in issue. The second part will be me again, talking about causation and what the Supreme Court has said about that. The third part will be Sarah Bousfield, also Brick Court Chambers, telling you about the trends clause, which is a very important aspect of the decision as well. All 3 of us were in the case for on 2 of the different insurers' teams. Both of our clients had what were called disease clauses, so we are better, sort of closer to the decisions on the disease clauses, which are perhaps the core ones, than we are to the prevention of access or hybrid clauses. And then the fourth part will be questions and answers. We've had 1 or 2 questions by email even before we've started. There's a chat box on the software which you can put questions through on. I should make clear at the outset that we're probably not going to answer every question, and there's a variety of reasons for that, which include the fact that we are acting for insurers involved in the case and the fact that we may not know the answer to all of them. So please don't be too concerned if your question is not one that we get to, but we will try to answer 1 or 2 that are representative and that we feel we can. So moving on from part 0 to part 1, I'll hand over to Michael.
Thanks, Simon. The test case concerned a claim by the FCA for declarations against 8 insurers concerning the extent to which various business interruption policies respond to loss caused by the COVID-19 pandemic. In broad terms, the case raised issues concerning construction and causation relating to 3 types of insurance clauses. First, the so-called disease clauses. These are clauses which provide cover for business interruption caused by an occurrence or manifestation of a notifiable disease within a specified radius of the insured premises. Secondly, prevention of access clauses. In other words, clauses that provide cover for business interruption caused by public authority measures which prevent or hinder access to or use of the insured premises. And thirdly, hybrid clauses, which combine elements of both the disease clauses and the prevention of access clauses. For the purpose of this seminar, I will focus on the disease clauses. The case also raised issues relating to trends clauses contained in the policies, and Sarah will be explaining those in a moment. The test case is undoubtedly very significant. It directly concerned 21 sample policy wordings. It is, however, intended to provide guidance on construction and causation relating to these types of clauses generally. The FCA estimated that the case potentially affects 700 types of BI policies and 370,000 policyholders, many of whom are small businesses. The case was commenced with the agreement of the insurers involved and was heard on an expedited basis in both the Commercial Court and the Supreme Court, given the need to obtain clarity on these issues as soon as possible. The speed at which the case moved through the courts was extraordinary given its scale. By way of illustration, as you can see on this slide, the claim was issued on the 9th of June last year under the Financial Markets Test Case Scheme. A trial based on certain agreed facts took place remotely in the Commercial Court around 6 weeks later, at the end of July. The Commercial Court handed down its judgment in September, and permission was then given for a leapfrog appeal to the Supreme Court, which was heard in November. The Supreme Court's judgment therefore comes only around 7 months after the claim was issued. The disease clauses had some differences of language, but they're all broadly similar. By way of example, you can see on this slide ARGENTA's disease clause, which states that it provides cover for business interruption as a result of any occurrence of a notifiable human disease within a radius of 25 miles of the insured premises. It was common ground that COVID-19 has been a notifiable disease in England since the 5th of March, when it was added to the list of diseases in Schedule 1 to the Health Protection Notification Regulations 2010. The FCA argued that each of the disease clauses provides cover for any and all consequences of the COVID-19 pandemic, including the national lockdown, subject to a precondition that there must have been at least one case of the disease within the specified distance of the insured premises. The insurers, by contrast, argued that the cover is limited to the consequences of diseases, the cases of the disease within the geographical limit specified by the policies. The Commercial Court judgment was given by Lord Justice Flo and Mr. Justice Butcher. They held that, with two exceptions, the disease clauses provide cover for the pandemic as a whole. As you can see from this slide, they agreed with the FCA that the insured peril for the purposes of these clauses is simply business interruption caused by the disease, provided that there has been at least one case of the disease within the specified radius. In other words, once that proximity requirement is satisfied, the Commercial Court held that there is no additional requirement for any causal connection between the loss and cases of the disease within the relevant geographical area. A policyholder only needs to prove that its loss was caused by the pandemic in general. In support of that interpretation, the Commercial Court emphasised that the policies do not state that the cover is only for the consequences of cases of the disease within the specified radius. They also relied on various factual matters which were said to support that interpretation, such as the propensity of notifiable diseases to spread widely and unpredictably, and the fact that the parties must have contemplated that any response of the authorities to a notifiable disease could be national rather than merely local. These factual matters were said to demonstrate that the parties did not intend to confine the scope of cover to the consequences of the disease within the radius specified by the policy. However, the Commercial Court concluded that the disease clauses in two of QBE's policies were limited in this way. The insurers argued on appeal that this was inconsistent with the court's ruling on the other disease clauses, and in particular, the insurers argued that the mere presence of the word events in those two QBE policies did not materially alter the scope of the cover provided by them. The conclusions reached on these issues by the Commercial Court were somewhat surprising, and they were very difficult to reconcile with the language of the policy wordings. The language of the disease clauses suggests that the scope of the insured peril is far more limited than that suggested by the court and does not extend to the pandemic as a whole. It is, however, worth noting that the Supreme Court of Appeal in South Africa recently reached the same conclusion as the English Commercial Court when construing a very similar disease clause in guard risk and Cafe Chameleon. The South African court in that case also regarded the proximity requirement in that clause as merely a threshold or qualifying condition for cover, rather than defining the scope of the insured peril. The majority judgment of the Supreme Court was given by Lords Hamlin and Leggett, with whom Lord Reid agreed. That judgment is a very strong endorsement of the insurer's case on construction of the disease clauses. After reading the first half of that judgment, you would be forgiven for thinking that the insurers had won. In fact, all of the insurers' appeals were dismissed, but that result followed from the court's conclusions on causation, which Simon will explain in a moment. As you can see from this slide, the Supreme Court held that the FCA's case as to the construction of the disease clauses was not tenable and involved an attempt to rewrite the policies. They held that the insured peril in those clauses is confined to individual cases of the disease within the relevant geographical area. The insured peril does not extend to the disease as a whole or the consequences of cases of the disease outside the specified radius. Lords Hamlin and Leggett also noted that, contrary to the Commercial Court's view, the business interruption itself is not part of the insured peril. It is merely a description of the type of loss or damage covered by the policy. In other words, it is the economic equivalent of physical damage in a building's insurance policy. However, that particular point does not appear to have been of any real significance to the result of the appeal. Lords Hamblin and Leggett emphasised the language of the disease clauses is not consistent with the suggestion that proximity requirement is merely a precondition with no causal significance. They said that if the clauses had no obvious meaning, the factual considerations relied on by the commercial court would be relevant in assessing which of the rival interpretations was more consistent with business common sense. However, that was not the case. They said that the meaning of these clauses was clear. As Simon will explain, however, the Supreme Court did nevertheless rely on those factual considerations when considering what the disease clauses require by way of causation. The FCA sought to defend the commercial court's conclusions on construction of the disease clauses on the basis of a new argument, namely a suggestion that the insured peril is an outbreak of the disease. An outbreak may well extend beyond the geographical area specified by the policy. Lords Hamblin and Leggett rejected that argument, noting that the clauses do not use the word outbreak, and emphasising that the insured peril is simply individual cases of the disease within the specified area. They said that the ordinary meaning of an occurrence, like an event, is something that happens at a particular time and place. An outbreak of a disease is a vague concept and could not normally be described as an occurrence unless there is a sufficient degree of unity in relation to time, locality, and cause. That, they said, is not true of a pandemic, which involves thousands of individual cases of the disease in different towns and cities across days and months, resulting from different sources. Lord Briggs, with whom Lord Hodge agreed, gave a concurring judgment, noting that he would have upheld the commercial court's ruling on construction. However, ultimately, none of this affected the result of the appeals for the reasons that Simon will now explain.
Thanks very much indeed, Michael. So I am going to attempt to explain what the Supreme Court decided on the subject of causation. So have the next slide, thanks, Paul, because Michael has dealt with construction. This is complicated. If you've sort of heard broadly what the result is, you may well be wondering how on earth did they reach it? And it requires a careful go through of what they said to try to understand what they've done and therefore what it may mean for other cases. The little numbers in square brackets represent paragraph numbers of the judgment. All I'm really doing is taking you through the judgment on this point and pointing out where seem to me to be the really important inflection points of the judgment. So we start with the basics of causation. The causation requirement in an insurance policy, which, as I'm sure you all know, is essentially that the loss must be legally or proximately or effectively caused by an insured peril. That's the essential requirement. And that requirement depends, of course, as they put it, on the legal effect of the insurance contract applied to the facts. One might say that means, well, it just depends what the contract says and then whether what happens falls within it. They make the point it rarely turns on specific words. So they are making the point there that cases which have sought to distinguish between words like arising from, caused by, arising out of, that's no longer the kind of approach that's being followed by the courts. And the general requirement is for proximate cause. And of course, they go through the fact that proximate cause doesn't mean the nearest in time and any of those things that it used to be thought to mean. It means the efficient, effective, substantial, legal cause of the loss. Now, I've highlighted some of what's said in paragraph 168, not because it's absolutely critical in this case, but because I think it is something that will be found very useful in other cases, which is an attempt to identify what actually is a proximate cause. And as you probably know, the other authorities on this tend to fall back on common sense and say the common sense of a judge can spot what's a real efficient proximate cause. They've had a go here at saying something a bit more specific, which is that the proximate cause of a loss is the cause that made the loss inevitable in the ordinary course of events. And that's an interesting point, which I think will have very wide application, not just in insurance, but elsewhere as well. Now we then go on the next slide to the doctrine of concurrent causes. And again, on this slide, we are mostly on that which is already fairly well known. It's fairly well known that there can be two proximate causes. There doesn't have to be just one. The test is often wrongly stated as being looking for the cause, and that's not what is being looked for. It's a cause, and that's because there are cases where there are said to be two proximate causes of loss. And in insurance, if one of the proximate causes is an insured peril and the other is not, then the policy responds, and that's the Miss JJ. But there's an exception. If the other cause is not merely uninsured, but is in fact an express exclusion from the policy, then the exclusion trumps the cover, and there is no cover, and that's the Wayne Tank case. The court pointed out that in both of those cases, in all of the cases that apply them, neither cause on its own rendered the loss inevitable in the ordinary course of events. It was the combination of the two causes that rendered the loss inevitable. And they then say, and this is obviously an important point relevant to this case, there's no reason in principle why the same analysis can't be applied to multiple causes which act in combination to bring about a loss. So far, the law has got as far as saying, well, you could have two causes that act together to make a loss. And if you do, if one of them is insured, then the loss is insured. But if one of them is excluded, then the loss is excluded. And we'll see where we go with that on the next slide, please. The next big argument in the case is whether but-for causation is an essential requirement of legal causation. And many of us thought before this case that the fundamental approach to looking for a legal or substantial cause was to first identify those of the necessary but-for causes that might be relevant, and then select from those which was substantial, important, significant, substantial legal cause. The majority of the court, the whole court, agreed that in the vast majority of insurance cases, and indeed any cases in the law of causation, but-for causation is essential if the cause is to be described as a cause of the consequence. But, and as you can see on the slide, it is a big but. There are exceptions where two factors combine to cause a result, and because of the other factor, neither cause is itself a necessary cause. So the examples they give in the judgment are: two fires start, they gradually together move towards a property, and they burn down the property. Neither fire is a but-for cause of the property burning, because the property would have burned by reason of the other fire. So for each fire, it's not a necessary cause, because the property would have burned anyway, even if that fire had not taken place. So the two fires together are necessary, but each one is not. And it's the same idea if there's a victim behind a bush, you can't see the victim, but two wrongdoers shoot at the victim at the same time. The victim dies, would have died if either of them had shot him. They were both good shots, particularly given they couldn't see him. And again, two causes, neither of them is necessary. But the point being made by the justices is, but we still want to call that the cause. We want to say that the building burnt down because of the fires, that the victim was killed because of the actions of the wrongdoers. Various other examples are given. They then acknowledge, on the next slide please, that the question of causation becomes much more difficult when you have a much larger number of separate events. And they point out, and this is a judgment that's full of references to scholars of philosophy and legal philosophy, scholars disagree about whether trivial contributions could be recognised as causes. So it's all very well if you've got 2 fires, but on the other hand, if you put a teaspoon of water in the ocean, are you causing the existence of the ocean? And so they say whether an event that's one of many that combine to cause a loss should be regarded as a cause depends on the context. And in insurance policy, what matters is the risks the insurers agreed to cover. Yes. And then they say, this is a question of contractual interpretation, which must accordingly be answered by identifying objectively the intended effect of the policy as applied to the relevant factual situation. And I've got here the shock horror emoji, at least that's what I think it is. I'm sure those younger than me on this call will probably tell me it means something completely different. But I've got the shock horror emoji here because I think, without meaning anything derogatory by this, of course, that this is the crucial sleight of hand in this judgment. Because if you read this judgment, you'll see it's full of orthodox statements, and yet it reaches a very, very, might be said to be a surprising conclusion. And what is going on here is that, having said that causation, according to all these wordings, is proximate cause, which means the cause that makes the loss inevitable in the ordinary course of events, which we've always understood to be what causation means, they then say that whether multiple causes count together as a proximate cause is itself a question of contractual interpretation. And the reason that I call that a sleight of hand is because it is uncontroversial, and what they've said so far is that what the causal test is, whether it's proximate cause or some looser causal test, is a matter of contractual interpretation. Of course it is, nobody could deny that. But having established that it's proximate cause, until this judgment, it was not previously thought that there was some other issue of contractual interpretation that could arise that would decide on how, whether something was a proximate cause or not, would be decided. So this is a crucial leap, if you like, or a papering over of the difference between one point and another. And if we turn the slide, we've got the next paragraph of the judgment, in which they say there's nothing in principle or in the concept of causation which precludes an insured peril that, in combination with many other similar uninsured events, brings about a loss with sufficient degree of inevitability from being regarded as a cause, indeed a proximate cause of the loss, even if the occurrence of the insured peril is neither necessary nor sufficient to bring about the loss by itself. And whether that causal connection is sufficient depends on what has been agreed between them. And this is really this is rather big news, because in the past, insurance cases have been decided on the basis that you could possibly have 2 causes acting together, and the insurance would still respond if one of those is insured and the other is uninsured. Here they are saying that you can discern from the policy, from what's been agreed, whether or not a particular large set of uninsured events with one insured event in them can also be treated as a cause. And this is a new way of looking at things. And as I've said, it is a change to suggest that you can do that by construction of the policy, when previously we might have said, well, the policy construction exercise will tell you that proximate cause is required. Whether it is proximate cause is then a question of looking at the facts and applying the principles of causation. But no, apparently you can get from the policy whether the insurance of one event is intended to cover that event when it can only cause loss in combination with many, many other insured events. So how do we tell, next slide please, Paul, whether it does or doesn't, whether it works or it doesn't work? And perhaps, sorry, I'll just pause here to remind you of the context. Why does all this arise? This all arises because, as Michael has explained, the Supreme Court, and this was only the majority, held that insurers were right about the construction of the policies, which meant that what they insured, what the insured peril was the occurrence of cases of COVID within 25 miles or whatever other radius, in one case 1 mile, of the premises. So that was the only insured peril. But most of the losses were caused by government interventions which were not themselves caused by occurrences within a radius of the premises, but instead were caused by occurrences all over the country. So it's a bit like the two fires, but instead of two fires, you've got hundreds of thousands of fires, and they all converge to burn down the property by the government closing down properties. But only one of the hundreds of thousands of fires was from an insured cause, namely cases within the radius of the premises. So how do you tell whether a particular policy was intended to cover one insured cause when it only causes loss in combination with hundreds of thousands of other uninsured but similar causes? And here the Supreme Court then brings in the background matters which were so important in the decision at first instance. They point out that the parties to the contract can be taken to have known that a notifiable disease might spread outside the local radius. They say that it could also be taken to know that government reaction to a widespread disease might be taken to cases both in and out of the radius. And they can't possibly have intended that in such circumstances, the insurers would be able to set up cases outside the radius all over the country as a countervailing cause to defeat the causal impact of cases within the radius. And they also point out that insurers do not expressly exclude cover for cases outside the radius. Next slide, please. They then deal with what might be thought to be the orthodox approach to all this. They accept, and it's quite interesting this, for future cases, they accept that the words of the policies are consistent with what you might think was previously the orthodox approach, namely that in order to ascertain whether cases within the radius are a proximate cause of the loss, you would weigh up the causal potency of the cases within the 25-mile radius of the premises against the causal potency of the cases outside. And if they were approximately equal, then you might well say that the cases within the radius were a proximate cause. But if they're not, if they're just the teaspoon in the ocean, you would say they weren't. But Lords Hamlin and Leggett say that does not make commercial sense in this case. Might make commercial sense if you could separate out the loss that was caused by different sets of cases. So if you had real loss caused by local cases, that would be one thing you might be able to do. If you had, for example, one of your businesses closed but the other didn't. But they say that's not what anybody would expect in the case of a widespread notifiable disease that might well cause government restrictions on a national level. And in those circumstances, it would never be realistic to think that you'd be able to divide the loss between loss that came from cases within the radius and those without. And so it just can't have been intended, and that you would get all kinds of paradoxical results, or whimsical, as they call it, results, if you tried to weigh up the cases inside and outside. So that in that way, they say the orthodox approach is a possible approach on similar wording, but it's not the approach you would apply to this particular case because of what we're all taken to know about the risks of infectious and notifiable diseases. So that is how they get to the conclusion that cases within the radius, that each individual case, in fact, each individual case of COVID is itself a proximate cause of all the public and governmental reaction to the COVID pandemic, and therefore of all the business interruption that resulted. Next slide, please. You might be relieved to know it's my last. Just a few very quick thoughts on what might be some of the lessons from this in a big picture kind of way. Courts in Australia, South Africa, and the UK have all made insurers liable for COVID business interruption losses on essentially every point that's come before them. None of them have found a way to do so, if I may say so, with great respect to all these courts, without, I put bending on the slide, maybe that's a bit strong, but certainly without some surprising development of what previously were thought of as the orthodox principles in this field. What does all that mean for the future? Well, it probably means that for insurers, if you have a peril which might turn out to be part of a bigger event, and it's possible that that bigger event may cause loss to the policyholder, then if you don't want to be caught in this kind of situation, it's necessary to exclude in terms cover for the wider event. And of course that applies particularly in business interruption, because the nature of business interruption losses, the fire example is obviously unlikely to occur with hundreds of little fires, although perhaps not impossible. If one was in Australia and talking about bushfires, it might not be impossible that one would be insured but not another, although it's unlikely because the general form of property insurance is for fire. But for business interruption, because of the nature of the loss, this kind of thing can happen, as we now know, and it may be that people, that clever policyholders and their representatives will think of other applications for it. Other litigants more broadly will try to use this judgment to argue that but-for causation is not a required feature of causation. My own view is that they are likely to find themselves knocked back, but it may take some time for the law on this to settle down. And as I mentioned near the beginning of my segment of this seminar, I think that what's effectively a new test for proximate causation in paragraph 168, namely that cause which renders the loss inevitable in the ordinary course of events, will probably have very wide application and may in time come to supplant, or at the very least augment, the traditional common sense approach, may help judges to apply their common sense. Thanks very much for listening to me. Sarah will now tell you about the trends clause aspect of the case, which is also of great importance, certainly to insurers and insureds.
Thank you, Simon. So as Simon suggested, we're now moving on to trends clauses. So Paul, if I can ask you to put the first slide, perfect. So before I go any further, what is a trends clause? I'm mindful that we have quite a diverse and large audience watching us, so I thought we should just start with the basics on this. The phrase is convenient shorthand used to refer to contractual quantification machinery that we typically find within business interruption insurance policies. So what these clauses do is they provide a means of calculating the indemnity payable in a relatively simple way, and therefore they bring some certainty to the contract. They circumvent what might otherwise involve a massive forensic accountancy operation and disputes between the parties to determine that indemnity. So what trends clauses do is they ask, but for the particular business interruption which has resulted from the insured peril, how would the insured business have fared? It may have been down on the previous year's profits due to general market pressures, in which case the indemnity would be reduced accordingly. Alternatively, the business may have thrived if the insured peril had not occurred, generating more profits than in the previous year, and if so, the indemnity may be increased. So both insurers and policyholders may look to trends clauses in order to either increase or decrease the indemnity. To illustrate the point, imagine a steak restaurant that had a business interruption insurance policy, which will now provide coverage from March 2020 for the BI loss caused by COVID-19 following this Supreme Court judgment. And let's also say it has a trends clause, which calculates loss by reference to gross profits from the previous trading year. This particular restaurant had a very good year in 2019. However, let's assume that there's solid evidence that this restaurant, like all steak restaurants, even leaving aside all the problems that have plagued it in 2020 due to COVID-19, was always going to have a much less profitable 2020 because of the increasing popularity of veganism. The indemnity payable under the BI policy will be trends adjusted, so an appropriate reduction will be made to the 2019 profits in order to the sum which represents the indemnity. Such adjustments can go either way, as I say. They can increase the indemnity if the steak restaurants were actually going to have a sort of bumper year and be even more popular in 2020 than in 2019 if the COVID-19 pandemic had not affected them. So as an aside, this process is known as looking at the counterfactual scenario, looking at what the circumstances would have been, all things being equal, if the business had continued trading during the period of interruption that it is claiming for. And we'll come back and I'll mention that term a little bit later. So Paul, if we can go to the next slide. This links back to what Simon has talked about this morning. So I just thought it's important to mention that trends clauses typically do include express references to the but-for test. They certainly did in the clauses that were considered by the Supreme Court. So how can it be that the judgment says that the but-for test need not be applied when we find the actual words but-for in these particular clauses? And in essence, that's because of what the Supreme Court has said in paragraph 260. These clauses are a part of the machinery contained in the policies for quantifying loss. They cannot be permitted to take away cover that is otherwise provided. So they do not act like an exclusion clause, for example. They are just a means of adjusting the indemnity sum payable. And I think once you have that clear in your mind, it makes what the trends clauses are doing much more readily comprehensible. Paul, if you go on to the next slide. So how did the Supreme Court say they are to be construed? Basically, they have been significantly narrowed, as you can only trends adjust for any trend or circumstance which is unconnected with the insured peril. You cannot adjust for circumstances arising from the same underlying or originating clause, as I said in paragraph 268. So let's assume our steak restaurant did most of its business from tourists travelling to the UK from overseas. The lack of international customers in 2020 isn't a trend that insurers can point to in order to reduce the indemnity payable, because the lack of international travel in 2020 is not unconnected with the COVID-19 pandemic. So next slide. How does the Supreme Court judgment compare with the High Court judgment in relation to trends? In short, they have a very similar conclusion. There is one difference, and for that reason, I've put out paragraph 278 of the High Court judgment at the bottom of this slide. That referred to the national outbreak of COVID-19, and it therefore appeared to allow scope for insurers to argue that the counterfactual would only strip out the consequences of the national COVID-19 pandemic, so that the impact of COVID-19, for example, assuming our steak restaurant is serving Argentinian beef, imagine that COVID-19 in Argentina was causing our restaurant supply chain issues. Based on what the High Court had said, it might have been open to insurers to argue that these non-national COVID-19 issues could still have been pointed to in order to reduce the indemnity payable. But regardless of what may or may not have been able to be argued in light of the High Court judgment, it seems clear to me that it's not longer. Paragraph 288 of the Supreme Court judgment notes that trends clauses cannot require losses to be adjusted on the basis that, and I quote, if the insured peril had not occurred, the results of the business would still have been affected by other consequences of the COVID-19 pandemic. So they no longer confine that analysis to the national situation, but just the pandemic at large. Moving on to the next slide. ORIENT-EXPRESS. So this was a High Court judgment, interestingly by Mr. Justice Hamblin, as he then was, on appeal from an arbitral decision by an arbitral panel, which included Mr. Leggett. Nevertheless, in the majority Supreme Court judgment written by the same Hamblin and Leggett, they both suggested that it was wrongly decided and overruled it. ORIENT-EXPRESS is a well-known case, but it concerned a hotel in New Orleans that was damaged by Hurricanes Katrina and Rita. Its insurance policy only provided coverage for physical damage to the hotel. It did not provide coverage for the damage to the wider city. So the High Court said, had the insured peril, the actual damage to the hotel, not occurred, loss would still have been suffered due to the surrounding devastation and the dearth of tourists. So what you would be able to say is that because of the effect on the city at large, which was not part of the insured peril, there would have been a reduced footfall and reduced level of trade for the hotel in any event. So you could trends adjust for that. ORIENT-EXPRESS has been subject to criticism from certain quarters by both academics and practitioners, because in practice what it suggests is that in cases of wide area damage, the indemnity payable will be lower in effect. The Supreme Court said that now that ORIENT-EXPRESS was wrongly decided, both the damage to the hotel and the damage to the city caused the hotel business interruption loss, and both arise from the same underlying cause, the hurricane. So you can't trends adjust to reflect the circumstances of the damaged city, as that is not unconnected with the damage to the hotel. In conclusion then, trends clauses have not reduced policyholders' claims here. They may well be something which is going to be revised in due course, so we might see a new way of approaching quantification of the indemnity, and insurers may look to more effective ways of limiting payouts in the future. And that concludes my slide. So I think we'll go to questions now.
Yeah, thanks very much indeed, Sarah, and thanks to everybody for listening through all of that. There's a lot of material there, and it's great to see the numbers of people in this seminar have remained at the high level at which they started. So thanks everyone for your concentration. We will endeavour to answer some questions. I've got a few both before the seminar and a couple that have been put already in the chat. Feel free to put some others in the chat. One of the questions before the seminar asked about businesses that suffer from supply chain disruption, and to some extent Sarah answered that in relation to the trends clause, that even if the supply chain disruption happens overseas, the trends clause won't save insurers from cover. Obviously, whether there's cover in the first place still depends on whether the business interruption results from cases of COVID, if that's what's insured, leading, and whether they lead this, you still need to find an insured peril. So there isn't necessarily a general answer to a question like that, because it does depend on what the cover covers. Sorry, in a sense, there's not much of an answer, but I think I don't know if either of you want, either of us want to have any further go at that question.
I agree with that. Provided that the cover under the relevant clause is triggered, and you can then show that the loss has been caused as a result of the pandemic, then supply chain loss, I suppose, has to be treated in the same way as any other loss that would be resulting from the pandemic.
Yeah. One of the other questions that came in earlier was, what's the impact of this on businesses that close because of COVID cases at their premises? And one answer to that is, if those businesses have a policy in the form of those considered in the case, then the impact of COVID at the premises is covered, because the radius clauses are all for COVID, are all for notifiable diseases at the premises all within 25 miles. So they will be covered. What is not so easy to say is what the impact may be on businesses whose business interruption insurance is only for disease at the premises. And I believe that there are some wordings out there like that. Those wordings have not been considered in this case, and it remains, I think, up for grabs whether what the right analysis is as a result of this case, and whether it applies to those clauses. And that leads me into a more general question which has been posted on the chat, which is whether the judgment is comprehensive authority for all BI claims, or will insurers who didn't participate have scopes to argue it doesn't apply to them? And then the fantastic question from the part of the same one, what are the principal loopholes, if any, that remain for insurers? Let me just try and answer some of that. The FCA tested what it understood to be a good selection of the clauses that were in the market, which it thought it had a real argument that they should give cover, and also which insurers were disputing cover. So it tried to cover the market by its selection of clauses, but it did not select clauses where there didn't appear to be any dispute because insurers were paying, and it did not select clauses where the FCA's lawyers felt they couldn't make a strong argument or an argument that they wanted to make that the cover was there. So there will be other clauses, for example, only ones that only refer to at the premises, which are not covered by the judgment. And obviously, in those cases, there'll be a matter of poring over the judgment and trying to work out what it means. In terms of being an insurer that didn't participate, I don't think that will make any difference because of the regulatory situation. The FCA will not permit any insurer to refight the case on the basis that it's not bound. That's not how it works because it's a regulated industry, and they will say that's not being fair to policyholders. So I think that's one of the benefits of going all the way to the Supreme Court, is that the law on how these wordings work is now settled. So that won't help. Principal loopholes I'm not going to attempt to answer. It obviously depends on the particular wordings, but if you've got a wording anything like the ones in this case, then there are no loopholes left, because those are points which any future court will say that one of the 8 teams of insurers would have taken if it was a real point. So I'm afraid if you weren't part of the case, you're probably stuck with the consequences of any points that any of us might have missed who were. Sarah or Michael, do you want to add anything on those questions?
I think it's quite difficult to add anything further, really. I think you've comprehensively covered it. I can't see, as you say, any further loopholes. I think we've exhausted all means on behalf of insurers of making all those points. So if there are any that we've missed, then we're, as you say, stuck with it. Yeah.
There's a question been raised about manifestation, which I think I know one of you two has got something to say on, because we discussed it earlier.
Yeah, I'm happy to take that, Simon. Yeah, we've had a question just clarifying exactly what was meant by manifestation of disease in the QBE policies. There are obviously lots of differences between the insuring clauses in say many in issue. One of the points was whether there was a difference between manifestation and occurrence of disease within the relevant policy area, and that was something that was looked at by the High Court. What the High Court decided on manifestation was that it required, if an individual was undiagnosed and asymptomatic, then that would not be a relevant manifestation of disease. It needs to sort of show itself in some way, whether by a test result or by symptoms. That was not subject to any appeal to the Supreme Court. So that position remains as it was before the High Court.
Thanks very much, Sarah. I hope that covers up that. I mean, somebody's asked whether we're seeing evidence of BI clause wording changing in the light of COVID, and if so, how? Well, I'm afraid, well, barristers always tend to be a little bit behind the curve on that, because we only get things when they come sort of a couple of removes on. I don't know. I'd be very surprised if insurers didn't start thinking more carefully about notifiable disease cover. There are plenty of wordings in the market which don't arguably cover COVID, because they deal with notifiable diseases with, for example, a closed list of diseases, which therefore never covers anything new. There are other wordings in the market that exclude some of the recent new potential pandemics. That's slightly less favourable to insurers, because obviously it depends, because the new ones you won't be excluded until the next year. But I'm sure that insurers will obviously be looking at their wordings with a view to limiting them for the future as a result of this. And that's why, in a way, a judgment like this is probably going to end up as something of a one-off, because the game of cat and mouse continues, and in the future you probably have to pay a very great deal for insurance that didn't rule out cover for all the consequences of a new pandemic, such as these covers have been held to be.
I agree with that. I think it's inevitable that the way in which these policy wordings are framed is inevitably going to change to some extent to take account of this judgment. The question about what a manifestation or occurrence involves raises quite an interesting question as a side issue that I didn't deal with. Paragraph, I think it's 208 of the judgment, refers to the fact that the parties cannot have intended that a person who merely travels through the relevant geographical area without any contact with anyone living in the area could trigger cover under those disease clauses. And that's in response to various hypothetical scenarios that were raised by the insurers to suggest that the FCA's interpretation of these clauses led to absurd results. And the Supreme Court said that the party did not intend cover to be triggered merely by someone passing through the area with no contact with anyone else. And it seems that the way to analyse that is that that does not constitute an occurrence or a manifestation. That I think is a qualification to the fact that an occurrence or manifestation simply requires someone to have the disease in the area.
Yeah, I agree with that, Michael. And I think one of the examples that they looked at was a passing train. So if you have an individual on a train that goes through a relevant policy area and who has either been diagnosed with COVID or has symptoms of COVID, they said that that wouldn't be a manifestation, just the passing of the train. But I think that there are still questions that remain about what if that individual got off the train. Let's say that they thought they were at their stop, but they weren't actually, and they simply stepped off the train onto the platform, realised they were at the wrong train station, and got back on and carried on their journey. Is that enough? We don't really have the answer to that. We just know that very transient passing through a relevant policy area won't count as a manifestation.
Okay, a few more questions have come in. A couple about reinsurance and particularly aggregation and how this might affect aggregation for reinsurance. That's a burning question and one which I'm afraid I am not going to say anything about. And I suspect that Michael and Sarah are in the same position. We obviously have been acting for insurers and continue to do so. I think that's all I can really say about that, but they're great questions. And in due course, we'll all find out the answers to them, I suspect. There's another question which I think I've already certainly hinted at my answer to, which is the approach of the courts in the three jurisdictions I mentioned a victory of judicial pragmatism, or does the departure for orthodoxy create legal uncertainty for future cases of a similar nature? Well, if this was an interview question, I'd say there's a false dichotomy there. It could be both. I do think that it is the application of a very high level of judicial pragmatism. I think that for many people, they might say that it was a strength of our common law system that there is enough flexibility in there that in a truly exceptional case, the courts can fashion an outcome which they consider to be the right outcome in a broad sense without damaging everyone's perception that we live in a place with the rule of law. I mean, Lord Denning was famous for, remains famous decades later for always seeking to reach the right result and for being clever enough to do it without usually warping the law in a direction which was unsustainable or caused too many problems for the future. I mean, in his case, some of his dicta have since been discarded as being not consistent with the broader fabric of the law. In this case, my own feeling, I think for reasons that I've tried to develop, is that the unorthodox aspect, at least of the Supreme Court decision, is one which probably can be accommodated and will probably end up being put into quite a small box of very unusual circumstances. Insurers will probably find ways of avoiding it affecting them so much, and it probably won't create so much legal uncertainty as to damage everybody's view that we nevertheless have a rule of law which is sufficiently certain that we can all deal with. anyway, that's probably enough philosophising from me. Michael or Sarah, do you want to do any philosophising? I understand. I think I've got some more questions coming that I haven't yet read.
I completely agree with that, and it's definitely a more satisfactory way of reaching the result that the Supreme Court reached by doing it via causation than the construction result that was reached in the commercial court, which really does, I think, stretch the principles of contractual construction to reach that result.
Yeah, I agree with that too. Yeah, a good question about policyholder providing proof of COVID, and this is something which was not appealed. The FCA tried to get into the case some declarations that would make it clear for everybody whether COVID had or hadn't occurred within particular areas, and the insurers successfully resisted the idea that the court was going to be in any position to deal with that in a test case brought on at great speed with no real evidence. So what was dealt with in relation to what we all call prevalence is to be found still in the first instance judgment of Lord Justice Flo and Mr. Justice Butcher. The short point is that for most policyholders this won't be an issue because there is enough evidence that COVID was very widespread from pretty early on in the problem, particularly now when any business that was going to be disrupted has been disrupted at great length. So it probably no longer matters so much whether there was a day or two at the beginning when it's difficult for a particular policyholder to prove COVID within the radius. But if there is that situation, if a particular policyholder is in a place where there was less COVID and it matters to their claim because of the timing, then it's a question of looking at all the available statistics and so on and trying to prove that there was more likely than not to have been COVID within the radius at the time. Although it may well be thought that lower courts will take a steer from what the higher courts have done in leaning in favour of the policyholder on such matters. Okay, I don't know if either of you have had a chance to look at the later questions. I haven't got beyond that question yet.
There's one of the more recent questions is, would the word only have made all the difference? Which I think is a reference to the disease causes. And I suspect that the answer to that is probably that it may well have resulted in, well, certainly in the commercial court, the Supreme Court's conclusion is that the insured peril is confined to individual cases of the disease in the geographical area. So the word only is not necessary, but in the commercial court, one of the things that they really relied on was the fact that it didn't contain the word only.
Thanks, Michael. I answered the question about at the premises before. Policies that are limited to at the premises, I think it's a difficult question and one that people will, which I don't want to express a view on, but there is a real question there, I think, as to whether at the premises policies respond. And the most recent question is the impact of a claims notification clause in the form of as soon as reasonably practical if people haven't put forward a claim. Well, I mean, I think we all know that the general principle is that unless the claims notification clause actually makes it clear it's a condition precedent, it usually isn't anyway, so it doesn't help insurers much. But I mean, even if it did, obviously, I suppose you then get into a dispute about whether it was reasonably practical to make a claim while waiting for the judgment, if that is what the policyholder was doing. I mean, if this was any other situation, you'd probably say that that wasn't a good reason to be not making a claim. You can still make your claim, even if you don't know for sure what the answer is going to be from the court. So, but I say it's hard to imagine in these kind of policies for small businesses that the claims notification is likely to be a condition precedent, but I will say. Right, I think that covers actually pretty much the bulk of them, and we are now on exactly 11 o'clock. So, I think I'll draw this to a close. Obviously, everybody listening knows where we are. If they want to ask further questions or better still instruct us to answer further questions properly. But so thank you very much for your attention, which is much appreciated, and I hope we've been able to be some use. Thanks, everybody.